Hello and good evening, everyone. My name is Lisa Cami, and I'm the Program Director of Education in Sacramento. Thank you for joining us tonight for California Lawyers for the Arts Annual Music Business Seminar. Tonight is the third installment in a four-part series of webinars that are designed to help artists in all phases of their career navigate essential topics in the music industry. Before we begin the program, we're going to watch a short video introducing California Lawyers for the Arts and the Music Business Seminar. We'll be right back.
Hello, thank you for joining us for California Lawyers for the Arts Annual Music Business Seminar. My name is Ned Hearn. I am an attorney in private practice, former board president, and current board member of the California Lawyers for the Arts.
My name is Gloria Ruiz Oster. I'm the Deputy Director and Southern California Director for California Lawyers for the Arts.
And I'm Eric Chun. I'm a musician and a professor in the Commercial Music Department at Merrick River College in Sacramento, California. I'm also a board member of the California Lawyers for the Arts. My colleagues and I are happy to welcome you to the 2021 Music Business Seminar. This year, since we're not able to gather together in person, we've put together 4 weekly webinars that bring together music industry insiders, scholars, legal experts, and marketing professionals to offer all the latest in music business insights to help you navigate an artistic career in 2021.
As a bit of background, California Lawyers for the Arts is a statewide nonprofit organization with offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego. CLA has been providing legal and technical assistance to the creative community since 1974. One of our core services is our State Bar Certified Lawyer Referral Service, which provides referrals to highly qualified attorneys who can work with you to resolve your legal issues in a professional manner. Depending on a client's income, legal assistance may be available on a pro bono or on a reduced fee basis. We also offer a specialized program in conjunction with the U.S. Patent Office that assists entrepreneurs and inventors and small businesses with patent applications. We also have a range of alternative dispute resolution services available, from negotiations counseling to mediation and arbitration, all of which can help parties involved in a dispute to avoid the expense of going to court and instead to find workable solutions through a confidential process guided by trained third-party neutrals. Lastly, we offer a year-long schedule of educational programs that include workshops and conferences and seminars like this one on various legal and business topics. Many of our previous programs have been recorded and are posted on our YouTube channel. And we hope you'll use these tools to stay on top of the legal issues that can affect your creative careers. We hope you'll follow us on social media to stay in touch and to learn about upcoming events.
Thank you to our sponsors and to the generous support we receive from our funders, members, and all of you here tonight for making this seminar and so many of our public programs possible.
I would now like to welcome California Lawyers for the Arts Executive Director, Alma Robinson, Katie Wagner, the Executive Director for Volunteer Lawyers for the Arts, which is in New York, and Keegan Royal-Eisenberg. Thank you and welcome.
Thank you. And I wanted to thank our team for putting this series together. We've had great input from members of our board of directors who are involved in the music and entertainment industries, as well as our staff across the state. There are many fabulous speakers in this series, and I hope you all are enjoying the program. I'm going to go through a basic overview of what we're going to do tonight. We will cover copyright and trademark basics, the DMCA, also known as the Digital Millennium Copyright Act. We'll look at a couple of examples of interesting copyright litigation cases and discuss the new Copyright Tribunal for Small Claims, which is going to be administered by the U.S. Copyright Office. Finally, we'll discuss mediation and how this alternative process for resolving disputes can benefit you, save money, save relationships, and help you resolve issues that are affecting your business. And then, of course, we'll have questions and answers. Now I'd like to introduce our friend Katie Wagner. Katie and I were last doing something similar in Austin, Texas at South by Southwest several years ago. And we've been collaborating throughout the years through our national network of volunteer lawyers for the arts organizations. So I'm really happy that she was able to join us and look forward to the program. Katie?
All right, let's get going. Let's talk some copyright, which is sadly one of my favorite things. I have such great respect for creators, mostly because I enjoy all forms of art and I try them, and I'm your lawyer. So I don't get to do that. You don't want me to necessarily play my guitar, which is over here. Anyhow, very happy to be here. Always happy to be with Alma. She's a great example of how to run a wonderful organization. So thank you for having me. Copyright, we need to start with the basics. For you lawyers, this should be a refresher. And for you musicians, you may be like, why are you talking about all these things? But I think it's a good foundation. We're going to try to keep it light on the law, if you will, and talk more in the practical sense, but I do want to give you this foundation. In fact, copyright not only is based in 17 USC, which is the US Code, copyright was, and all the intellectual properties are grounded in the Constitution. So it is a constitutional right that our founders thought was important to give and to incentivize creators to create their artwork. And to do so, they provided a limited monopoly of time, which we'll talk about. It has changed over the years, but we'll talk about what that is in just a minute. But gave that right to Congress to create the laws around that. And so copyright is a federal law. And so no matter what state you're in, this is the law of the land. Copyright, what is copyright? Copyright gives you this exclusive right to do things with your work. And that includes reproducing your work, creating derivative works of your work, which means that you can decide whether someone uses your work and create something in addition to it. A good example of derivative works actually is the song and the recording, right? Recording is a derivative work of the song or the musical composition. Distribute to the public, perform or display the work publicly. Displaying of the works, it's one of those bundle of the copyright that wasn't really, it was kind of dormant, I would say, until the internet popped up into the world. Now people really pay a little bit more attention to it. So it's good that we have that. And then the performing of a sound recording. Now, there's an asterisk next to this that's going to be relevant when we talk about one of the cases tonight, because there have been several iterations of the Copyright Act. And until the 1976 Act, which became the law in 1978, or became active in 1978, you could not copyright a sound recording. It was all governed by state law. And so that has affected many of the older recordings, including one of the songs that we'll talk about, or the cases of recent cases we'll talk about tonight. The copyright also allows you to decide and authorize other people to do any of one of these works of the bundle of rights, right? So you can say, you can reproduce the work and you can reproduce and distribute it. You can create a derivative work. You can do it for this amount of time. If you want to take either one of California Lawyers of the Arts copyright classes or mine, I'll go into greater detail. But for today, let's talk, I'll point you to some very informative information which can be found in the Copyright Office. Copyright.gov has a great deal of free information, including circulars on copyright basics, which will go into details that will be helpful for you to ground yourself a little bit more in some of these concepts that we're going through this evening. It is important, I hear this question a lot, do I need to register my copyright? And what does that even mean, right? Well, the reality is when you create something, when you put pen to paper, when you put paint to canvas, when you record a song, when you write the notes, when you write the music to a composition, you own that copyright in that work. You are the author, as they say, of the copyrighted work. Anything that is fixed in a tangible medium, that's all that it takes to gain a copyright, to have a copyright in something. However, If you don't register it with the copyright, then you don't have certain advantages that registration gives you. Unless you register your copyright, you can't sue in federal court. You have to, which is where you have to sue, it's federal law. You cannot sue under your copyright unless you have registered it. And so you want to do that. If you register it before someone has perhaps infringed your work, they've taken it, copied it, distributed it, it can mean that you get statutory damages, which means that you don't have to prove damages. You get a certain amount of damages, which is, I think, 15,000 to 150, if I'm right, somewhere in there. And attorney's fees, if possible. There's certain rules, but that's an incentive for people not to infringe on copyright, which is not always granted in the US. It can also be prima facie evidence of the validity of the copyright, and it certainly proves a no later than creation date. One thing that people ask, well, can I mail a copy of the music to myself? And the answer is, well, you can, but your evidence is only good as proving that you didn't change the date or steam an envelope open, or it's not really a strong evidence. So it's very good to have the strong evidence in the Copyright Office of the registration. One thing to know is that when you're registering for copyrights in music, there are two different copyrights. There's the musical composition, which is the song, and there's the sound recording. So that ownership is separate, as you all know. The musical composition is created by the songwriter who creates music and lyrics to the song. It's usually owned by the songwriter and the music publisher, possibly, certain producers, that sort of thing. And sound recordings are fixation of the musical spoken or sounds of any composition, and it's owned by the performer or the record label. So as I said before, the sound recording is actually a derivative work, usually of, a musical composition. It could be that you've written and recorded the song, and then you're both, and you have both copyrights, or you could have one. And as I mentioned before, you did not have a performance right in sound recording before 1976. So how do you register? Actually, and Keegan will talk in a minute about trademark. And I have to say that the good news is the copyright is so much easier to register. It's a very simple process. You go, copyright.gov, they encourage you to register online. And as you can see from the fees, $45 to $65 for online. That depends, there's a fee schedule, but it will depend on if there's a single author, a single song, that would give you the lowest fee, and then it increases from there. And if you want to still do it on paper, you can, but it's going to be $125. So you can see right there, they're trying to incentivize everything to be registered online. It's really like a one-page form. You need to identify the author and the claimant, identify any limitations to your claim, and include a deposit copy. So that would mean the sheet music, a copy of the recording. There are several different forms that you'll have to use. One is PA, one's a SR. So there's a musical composition, sound recording alone, and then you can use the sound recording for the combination of the two. And so just because everyone, I think, while I say it's easy, they make it easy for you by having these circulars on registration of each of these different works. And so as you'll see there, circular 50, 56, 56A, and 34. So application, deposit copy, and the fee. But it's a very low fee, as opposed to, as we're going to find out, trademark. Copyright duration, which perhaps the way I started my conversation, I could have set it up there. But right now, if you create a copyrighted work and you're the author, you have life of the author plus 70 is the length of time that your copyright exists. So that allows your heirs after you are no longer with us to have the benefit of your copyright. There's also work for hire, and work for hire is 95 years from publication or 120 years from creation, whichever shorter. Again, more asterisks, and that's because of the earlier versions of the Copyright Act, which had much stricter requirements for renewals of copyrights. And so if you have an earlier work that you're interested in using, before you consider that it might be in the public domain, which means you can just use it for anything you want, you should go back and check the math and talk with someone who can work your way through the Copyright Act. But it is definitely a little bit of a maze. So Just a little note there. And now I think we'll talk about the differences between copyright and trademark.
As Katie mentioned, there are some differences between copyright and trademark. And the main difference is what those two types of law and what those two rights will cover. So for copyright, it's going to cover original works of art that have some element of creativity and are tangible. So it doesn't cover ideas that you have until you put those ideas in something that you can touch, like a sculpture or a piece of paper where you've written it down, or a canvas that you painted on. A trademark covers the logo or the name of a company or it's a brand, and it's protecting the goodwill that the consumer has when they think about that logo or that brand name. So no matter what your feelings are on Nike, for example, you think about Nike and you think about that company. And so if you saw some shoes that had the word Nike on them, you would hopefully be right in assuming that those shoes were made by Nike. And the trademark registration that Nike has on their name protects them, and they can prevent other companies from using that word on their shoes as well. And so if you feel strongly about a brand name, then the company that owns that trademark enjoys that strong feeling that you have, and they want to make sure they can protect it. So trademark protects words, protects logos or combination of words and logos. There's actually trademarks for sounds. So like the NBC chimes are a trademark for NBC. There's a trademark for scents, which is, it's rare, but Play-Doh just got a trademark for the scent of Play-Doh. And there are some trademarks for colors, but it's a little bit hard to trademark a color. Colors are very utilitarian, so it's very difficult to say that every time you see this color, it's only going to be associated with this company, which is what a trademark registration is supposed to help with. Many people see colors differently, like the black and gold or blue and white dress debacle that we had. So it's kind of hard to make sure that the color that's being protected is the exact color that's supposed to be protected, because the trademark registration prevents other people from using that word or logo or sound associated with their company or their product. So how do you register a trademark? Well, you go to the uspto.gov, and they are also trying to encourage people to register online. They're also a little bit more expensive. And the registration fees are per class. And there's a lot of different classes depending on what kind of good or service your company is making. So for one class, it would be $250 if you are an attorney and you're filing this registration. You would use TEAS or TEAS plus. If you're not an attorney, you can still file online for one class. It's $350. But the United States government has recently said that you have to be an attorney to complete the registration of trademarks. So you can file as a non-attorney, but then an attorney has to take over and help you with the rest of the registration process. And it's not just a file it and forget it kind of a thing. We're going to talk about more things that happen after you do file that registration. And then if you have a registration in another country and you want to transfer that into the United States, then it's going to be $500 online. Or if you don't want to do it online, you can do it paper, but it's going to be $750. And this is all per class. So if you have a company that's going to be producing t-shirts and posters and mugs, those are all 3 different class numbers. So you're going to have to pay for each of those classes. You can put them all in one form if you want to, but some attorneys recommend filing different forms for each class. So one class per registration, because in the future, there might be a scenario where you would want to change something about how your trademark is registered. And if it's one class per registration, it's easier to do that change. But it's always up to you, and you want to talk with your trademark attorney about whether that's the right choice for your trademark. Now, before you register your trademark, before you submit that application, you might want to do some research, because if you're trying to register a trademark that's very similar to somebody else's, the USPTO is going to have a problem with that. So you want to look and see if anybody else is using the same logo or the same brand name or combination that you are for the same goods that you want to sell or the same service that you want to provide. Some of the bigger name companies, they are in a lot of different markets for goods and services. So it's really hard if you wanted to make Nike automobiles. You might be able to do that, but you couldn't make Nike shoes because Nike already has a trademark in the class of selling shoes. They might have a trademark in the class of selling cars. I don't know. But you want to see if somebody else has a trademark in the same area or of goods and services that you want to be selling your trademark. You can do this yourself. You can use Google and you can do some searches, or insert your favorite search engine. But there are companies that you can pay to search, and they have a very extensive and highly proprietary method that they can search, and they'll find all the things that are exactly like your trademark or kind of similar to your trademark, or maybe not very similar, but still has some connection. And those services are kind of expensive, but they are recommended most of the time because they'll help you to figure out if you are going to go down the rabbit hole of registering your trademark and then going back and forth with the USPTO over why your idea for a logo or a brand name is actually not anything like that other one that they're telling you it is. And if you can find that out beforehand with that search, then you'll save yourself some time, and you might think about choosing a different brand or a different logo. And then you want to think about, are you going to file a registration that you're using the trademark right now, or that you intend to use it? And if you are using it right now in your goods and services, then that's great. And if you've been using it for years and you're just now registering your trademark, you do get to let the trademark office know that you've been using it since 1985 and you've been selling your goods, or you've been using it since, just last week. Or if you intend to use it, you can file a registration now, but you need to make sure that you start using it in commerce within 6 months. If you don't begin to use it, you have to file an extension that you intend to, and you can do that a couple of times. But they really want to make sure that people are using their trademarks in commerce and not just parking on them and keeping other people from using them. And then when you go to register, which class of goods or services are you going to choose? What are you trying to sell? Are you selling a product, or are you selling something where you provide a service? And you want to make sure that you choose the right class, because if you choose the wrong class on your registration, then the USPTO is going to want to talk to you about that, and you have to go back and forth. And you want to get that right probably the first time so that they don't have any problems with your registration application. Also, do you want to register a word or a logo or a combination of both? And when you file your application, you need to provide a specimen. So you have to have something that is either just, if it's just a word, just the word, and not really any special font or anything like that, just the word in plain Roman alphabet letters. If it's a logo, you need to show the logo as it exists on the goods or services that you're selling. So it can't just be a drawing of what your logo is unless it's an intent to use. But if you're doing it in use, it's got to be, this is what my logo looks like on the side of my truck or on the box of crayons that I'm selling. And then prepare for office actions, because it's highly unlikely, even with the best trademark attorneys, you will get an office action. The USPTO wants to make sure that before they give you a monopoly on this word or logo that nobody else is allowed to use with those specific goods or services, they want to make sure that you have your application completely and perfectly filled out. So a lot of times you'll submit and then they come back with a question. Hey, it seems like your brand is a little bit too similar to this other brand that already exists. Can you tell us why that is? And can you maybe explain, how they're different? Because otherwise we can't give you a registration. And that's a likelihood of confusion. Or maybe your brand name is merely descriptive, like tasty chips. tasty chips is just describing how the chips taste. And unless you have a fanciful way that you've spelt tasty, they're probably going to say, no, that's just describing the flavor of chips. And if we let you call your chips tasty chips, nobody else is going to be able to say that their chips are tasty because it's going to be your trademark. So they're going to say, no, please figure out how this is not merely descriptive. You also can't have something geographically descriptive unless you have a specific designation. Like you can't say that your cheese comes from France. It's French cheese, unless it does come from France. And then it's not really a trademark. It's something a little bit different. There's been some recent cases involving scandalous trademarks. The First Amendment does allow you to kind of say a lot of things, but the USPTO has been kind of hesitant to grant trademarks over bad words or insults or racist epithets. But you can try. They might just push back a little bit. You can't use people's surnames unless you are that person or you have their permission. And your trademark can't be merely ornamental. It has to actually be something that is going to associate your product or service with your company. And you also can't use flags. Like the American flag cannot be your registered trademark. It can be a part of your trademark, but you can't exclude other people from using the American flag. So you can't claim that that's part of your logo. It can definitely be on your product if you want it to be, or any other flag, but you can't claim it as part of your registration. So that would keep other people from being able to use it as well. Then after you've gone through all the office actions and everything is okay and the USPTO grants you your registration, don't forget to maintain it, because although you've paid fees per class and now you have your registered trademark, you still need to make sure you keep up with that registration. Between the 5th and 6th year, you have to say that I'm still using it, please don't cancel it, and give them $225 per class. And then between the 9th and 10th year, you have to say, I'm still using it, please don't cancel it. Also, I want to use it again for another 10 years. And you have to give them $525 now. And then every 10 years after that, you have to give them another $525 and continually tell them, I'm still using it, please don't cancel it, and I'm going to continue to use it. And as long as you do that, your trademark will last forever. Unless it gets canceled for a reason other than you not paying your maintenance fees, you can continue to hold your trademark as long as you use it in commerce. And so there's companies that are very, very old that have the same name, like Coca-Cola, or there's probably a cigarette company or two that has a very old trademarked name. And as long as they continue to use it, then they can continue to pay that money each year and they'll have that trademark. So like Katie talked about copyrights expiring after the life of the author in 70 years, trademarks don't expire unless you stop paying. And so with that, let's move on.
And back to Katie.
All right. Well, one other fun thing about the Copyright Act that I think is relevant to music is the Digital Millennium Copyright Act. You know it as the DMCA. The DMCA was Congress's solution to emerging technology in the 90s. I feel old when I say this because I was graduating law school, but the DMCA was enacted in response to the absence of laws between technology and copyright. So they were trying to address chat rooms, basically, right? Someone uploading a song to a chat room would be considered infringement, but Verizon and AT&T are like, we can't control that. We need to have some sort of safe harbor. And technology companies said we need to be protected so that we can innovate and allow this to flourish. And so a deal was struck that yes, that's true. You can, as long as you're a good corporate citizen in terms of making sure that if someone tells you that their work is being infringed on your service and you take it down, then that's okay. So they created, and it was so early on, they called them online service providers, OSPs. But of course, we think of them more as ISPs now. It could be your typical conduits like, Verizon, but all the different providers of your cable services. But then there's also the creation of the YouTubes of the world. And YouTube has had a big case that came down, in fact, on the DMCA and won their case. I happen to be on the other side of that case, but in terms of avoiding liability because they had followed the rules under the DMCA. So there are two things. First, if you are a service, if you have a service and you want people to upload music to your service, then what you need to do to comply to be this good corporate citizen and to be protected from being liable for copyright infringement if someone uploads someone else's work to your site. You have to adopt and implement a takedown policy for copyright infringers. So you have to be able to say, if you find that your work has been, if you are uploading work that's infringed, it will be brought, down and you will be liable and all these kinds of things. And you have to designate an agent with the register of copyrights. The idea being that, and this of course shows you when it was written, because they were thinking you were going to send them a paper letter to tell this designated agent that on the internet somehow my work was being infringed. The idea of this was supposed to incentivize the creators, the musicians and songwriters or any other creators, because it was going to be one step before having to start a federal lawsuit. The only way prior to the DMCA that one could address someone infringing their work was to literally file a federal lawsuit. So they said, okay, we will create a process that instead of sending the scary lawyer's letter and having to start a lawsuit, we're going to create that process prior to it. And to be a good corporate citizen, the website who is taking advantage of the safe harbor must abide by these rules. So what do? You have work that you found on a website, it's been infringed. What they envisioned and what needs to be given to them is this information that it's your work, you identify the material, you actually, according to some case law, have to identify the URL. That's was a problem with YouTube because it could just pop right back up, right? You take that one URL down, it comes back up. You have to have content information. You have to have a good faith belief. Then you have the provider needs to take it down almost, I think 2 or 3 days in a very reasonable short time. And then they give notice to the person who had uploaded it in the beginning. If that person comes back with this counter notice and swears that, no, it's my work, I have ownership of this under a penalty of perjury, this is a mistake, they'll put it back up in 10 to 14 days, and then you have to file a federal lawsuit. So it's one step ahead of it. So it's kind of the scary letter online in a little bit of ways with a bit more teeth, because there are some provisions where that good corporate website citizen has to follow these rules, so that it has to come down. And if that person is caught 3 times, then the website needs to keep them down forever. In practice, when I was at the NMPA, there was a problem. The Googles of the world, Jeeves Ask Jeeves or whatever these, the different ask.com, I guess it is now. They wouldn't take it down after 3 times because and then one of them, I won't say which one, said, well, someone else is not doing it, so we can't do that anymore. They used to take them down and then they stopped. So, it was a good idea in 1995. And now you do see, if you go on YouTube and you type, takedown policy, you're going to get a page that's going to show you, that you can fill out all this information here in this takedown notice, and you press send, and then that's where you see the notice that the request of the owner of this music has been, or this video has been taken down. So it has some effect of, accomplishing the goal, but it's not complete. And I think at this point, the technology has really outgrown this concern, because the people who can find the information the best are the technology companies, but it shifted the burden, right? Before, you couldn't get access, and we'll talk in a minute about these cases. You didn't have access unless somehow you got it outside of the very public internet. Now you type in the name of a song and it pops up, right? So it's very hard to police, but then the burden is on policing is on the creator rather than the user of or the infringer of the song. So it's much more burdensome for creators and owners of copyrighted work, I think, on the internet. And we'll see if that changes when, I don't know, Alma, when do you think they're actually going to get around to finally fully, I guess, revising the Copyright Act? It's under consideration in Congress. It moves oh so swiftly, I shall tell you later.
We have a crystal ball.
Yeah, I don't know. So maybe in another 10, 20 years or so. But there is consideration going on in Congress about what changes need to be made. But there is a third player now, right? You know, for example, in music. In music, it used to just be recording companies and the music publishers, right? And those were the two people who were talking about music copyright. And now you have the technology companies, and the technology companies in all areas of copyright, it's what makes their machine run. And so they're very involved in all of the policy. So it'll be interesting to see what comes of that. But I'll stop my my soapboxing and we'll move on to the copyright case discussion. And actually these cases that we're going to highlight, both from California, probably you've heard of a little bit in the news. That's the sexy part of music law, right? Is that actually occasionally we get cases. And as I said, a lot of the cases that we've seen recently have seemed to go against the creator. In this instance, well, I can't reveal yet because we're going to take polls. So we're going to do two cases. Let's start with the first one, Keegan, and see what people think. We want you to listen to these two clips. These were the two clips at issue. The case was Stairway to Heaven, and it was Led Zeppelin was being sued by Spirit for the song Taurus. So here are the clips.
Okay, so here's Taurus. Okay, and then here is Stairway to Heaven. Is this infringement?
I'm going to say you're all right, and that's no fair for me to say, is it? But this is, and Alma, I'm going to just give you a lead into talking about arbitration mediation and the benefits of it. The result was that the lower court found no infringement. The appeals court said overturn that decision, reverse that decision, and then en banc, which means the entire circuit court, reinstated the trial court judgment. So they said no infringement. There are a few things, and before I'll go into these, I'll just give you a little bit of background that may have played a role in this, even though, you know, there's technical. When you're looking at music copyright infringement, you're looking at access. Did they have access to this music to even copy it in the first place? And was it substantially similar? And you can look at that both factually and as a matter of law. You know, musicologists get involved. In this instance, they were looking at 5 notes, I believe it was, only 5 notes. It was the arpeggio. I am not a musician. I love music, but so they were really looking at a short amount of the music and looking at it very technically. But in addition to that, courts do get swayed a bit by some of the facts. And the facts in this case were that the composer, Mr. Wolf, Randy Wolf, he created this work in 1967, or at least copyrighted it in 1967, and then continued to play it continued to play it throughout his life until he died in 1997, I believe it was. His family created a trust, and in 2006, they sued for the first time Led Zeppelin, saying that there was copyright infringement. So clearly there was a long time in between that, and the composer himself never sued for copyright infringement, right? So when you're looking at that, that is a fact that, you know, can give you pause as to, you know, if the composer didn't think it was, although I think I heard some stories that maybe he was talking a little bit about that he had. In the long run, what the court decided was that you have to have a certain length, a certain amount of originality. We talked about originality when what makes a copyrighted work, what's copyrightable. And these are notes. and there are only so many ways you can put 5 notes together. And they, they looked at the musicologists and they said, no, there's not enough there to be copyrightable. But there are 3 major impacts that I think were helpful for the Led Zeppelin case. The first one is the arguments of the plaintiffs were, well, he admitted. So what happened was, even though there was no proof that they performed together or that Led Zeppelin actually heard the song, they actually conceded, you know what, I own a copy of the record. So that's fine, I have access. In past cases, if you have access, then you don't have to prove as much about the similarity of, or the similarity of the cases. It doesn't have to be exact. If you're proving that you have had access to it, but as I talked about, access is very different now than it was 30 years ago, right? So one thing that the court looked at was the inverse ratio rule. So again, copyright infringement, access plus substantial similarity. If you have access, then in the past, there was a lower standard of proof for substantial similarity. But the panel said, the plaintiff said, I should have had an instruction. So now we're getting into the weeds of litigation where you have jury instructions. And they said it was an error in the lower court because they didn't instruct that they should have this inverse rule. So we don't have to prove as much. We don't have a higher standard. And the panel went one step further and said, this is a ridiculous rule. Just because you have access doesn't mean that you don't have to prove substantial similarity to the satisfaction of both of the tests, which, and so that I think is a big deal for future cases where you can't just say, especially in this day and age when, of course, you're going to be able to prove some, can you prove exactly that they viewed the page? No, but can you say, it's out there, and we'll talk about this in the next case. It's out there. I've won awards. That's enough for access. So I think it makes sense, this ruling, that there's no longer this inference that you don't have to prove as much in substantial similarity. So the next one is a little bit, interesting to me. But so one of the complaints about the instructions, again, was that they wanted an instruction. The instruction said that there are common musical elements like arpeggios are not protectable, but they omitted something saying that, but an original selection and arrangement of unprotected elements can be protectable. And while that's true with 5 notes, and that can be very difficult to prove, right? And the court punted on this one, I think because they saw, or they found very clearly that it was an infringement in their mind as a matter of law. And so they said that, well, you didn't bring that up before, so because it's not a plain error of the lower court, we're going to ignore that. We're not going to rule on it. But because it really is important in these areas, you musicians, I'm sure know, there are only so many ways that you can put notes together, right? There's a lot of different musicality that goes into it, but there are certain things that sound good and there's certain things that just don't, right? And so if there's enough out there, you can't protect that. It's just in copyright, you can't protect things like scenes of fair. So it may be boy meets girl and they kiss in the rain, or any other sort of very common, the alphabet, measurements, things like that. And so this falls into that in the musical realm, right? That there's only so many ways you can put this together, and with only 5 notes and with differences, because they noted that there were 2 different layers to Led Zeppelin versus Taurus had only 1, right? A little bit about the arpeggio. And then the final one, which was the most important and probably the one that you heard reported and might have been a little confusing to you, is that if you remember, there wasn't a sound recording copyright in 1967. It was a state right. So the only thing that could be copyrighted was the actual sheet music. So the musical notation, he did the right thing, Mr. Wolf, and copyrighted the song Taurus and deposited a 1-page sheet of music for the song. And in the appeal, they said, well, it wasn't fair because the lower court didn't let us play the song. And the court said, no, it would have been error to play the song because the only copyrighted issue was the piece of paper, was the actual notes that were registered with the Copyright Office, that deposit copy. That's the only thing you can look at. And yes, you're claiming you want to use it to show access, but look, he's already agreed that he had access. So you understand now why he said, oh, sure, I have a copy of that album, right? Because, well, you don't have to prove access. It's been proved. So you don't need to play the song, which a lot of you thought sounded extremely similar, right? It does sound very similar. And if you just look at the sheet music, then we look at it, the notes are different. There are only 5 notes and no infringement, right? So that's when you get into technical. But so the big deal was that they decided it was to be decided under the 1909 Act instead of the 1976 Act, because then they would have had a sound recording copyright, and then they could have played the sound recording. You are entirely able and should upload the recording of your music when you're getting your copyright. And that's why. And so now we'll go to the next one, which is also something that's been in the news. As you know, Katy Perry with her song Dark Horse and the song Joyful Noise by the rock rap Christian group. So let's hear it.
Okay, so here is Flame. And then here is Katy Perry.
Here you were gonna come to me. Here you are, but you better choose carefully.
Is that infringement?
All right, again, you're both right, and I'll tell you why. I don't know if you're right, but I'll tell you what happened. So this one at least was a little more current, of course. It was the Christian rapper known as Flame, but his real name is some Gray. His last name is Gray. Claimed that Katy Perry had infringed. The jury agreed. The jury said that sounds the same. You're right. $2.8 million. There you go. The defendant filed a motion for a judgment as a matter of law and for a new trial. And the court said that, and this was actually pretty extreme. I mean, this doesn't happen that often. This is very rare. But the court threw out the decision of the jury and entered a judgment for the defendants because they said as a matter of law. So there's 2 things. A judge decides the law of the case and the jury decides the facts, right? So if there are no facts in dispute, the court can make these determinations. Usually it would happen on a motion for summary judgment, but I don't know in this case procedurally if they made that motion. I probably think they thought they needed to go to trial, but after all the facts were on the table, the judge decided, well, yes, I guess they made a compelling argument, but it's as a matter of law, this ostinato, so again, more terms, and similarly, it was only 8 notes, right? So we're in that tune area, but only 8 notes, and claimed that it didn't meet part of the substantial similarity. So in the substantial similarity, you have both an extrinsic test, which is basically the matter of law. Does it meet the standard of being a copyrighted work or copyrighted work? And then also, is there the intrinsic, which is more of the facts? It's the common person listen to it like us listen to it and saying, yeah, we think it sounds the same, right? But in this case, they didn't have to get to that, does it sound the same question, because the judge said that it's such a commonplace expression, again, only 8 notes, no music creator can monopolize that, right? If you said, okay, you get those 8 notes in that order, then that's gonna stifle the creativity, which is of course the whole purpose of copyright. And they also said, but even if we said there was protection, it's very thin. And if you have a thin protection of copyright, it has to be virtually identical. And here we don't find that, that it is that identical. So they said no. So in both these cases, it actually turned out, well, I guess it depends. They're both musicians, right? So, but in terms of the defendants, they were able to defend their music because the parts that were being taken were quite small. And I think that the facts were pretty, just in terms of the music, it's very difficult to monopolize, as they say. So good news for Katy Perry, although $2.8 million may not be that much for her. I don't know. Alma, do you have any thoughts on that?
Well, I'm curious about how much people will invest in the appeals process and getting into the procedural aspects of jury instructions. It's very arcane and complicated.
Yeah.
And so I guess when there's a lot of money at stake, people can imagine anything and take it into federal court to sue.
That's true, but that is one of the challenges for us. Obviously, you and I both are in the same position of helping artists that are newer in their careers or don't have the financial means, and so we find it very difficult sometimes when you're up against Katy Perry or Led Zeppelin to see a lawsuit all the way through, because even if you just go through the lower court and you go to trial, that's a good 2-3 years probably, right? When they start the suit, 2013, it just got decided. You're going through the courts, you're going through depositions, you're going through other kinds of discovery, paper discovery. Now you've got them, they probably want to see all of your files on your computer, and do a real investigation of your online footprint. So it can be very, very expensive. And so I think what you're going to talk about right now and what I've been very excited about for a long time is interesting. So I'm turning it over to you.
All right, thank you. Well, here's our shiny new thing. This was a gift in the stimulus package that was signed by the president at the end of the year, the end of 2020. And it will go into effect as early as a year from the date of signing, which would be December 27, 2021, and they sort of put in 6 months of wiggle room. They said it could actually be implemented 6 months later as they work out regulations and procedures. And it's interesting because they've been talking about this since 2006. There was a hearing in the House Judiciary Subcommittee on intellectual property, and that was 15 years ago. So they've been thinking about this for a while. California Lawyers for the Arts, as well as Volunteer Lawyers for the Arts and many others around the country, weighed in at various hearings that were held around the country. And people were really advocating for a small claims procedure for the copyright issues so that you wouldn't have to go to the huge expense of filing in federal court. You don't need an attorney necessarily, and your claims can be as small as it can be $15,000 or $30,000, depending on the circumstances. So the U.S. Copyright Office is going to create this Copyright Claims Board as a 3-judge tribunal. So statutory damages, as I said, limited to $15,000 per claim, or up to $30,000 for a total amount of damages per case. Judges can award separate attorney's fees for up to $5,000. However, attorney representation is not required. It's curious that the defendant can opt out within 60 days. So it's a voluntary process for the defendant. And the theory is that the claimant will have an option to go to federal court if the defendant doesn't want to resolve this in the smaller jurisdiction limit of 15 or 30,000. And in federal court, you can claim statutory damages for up to 150,000. Again, you would have had to register your copyright before you can claim statutory damages. There will be a filing fee of at least $100. And I'm curious as to how that might work out. It's not limited to $100, it's at least $100. And it's also curious that the 3 judges will be making a joint decision on each case. I'm really surprised that that's how it's going to work. That sounds like an en banc panel, as we have in federal court, and you appeal, and sometimes you get the whole court, not just one person. And so it's very odd. They will also be hiring some attorneys to assist in the process. And what I have also learned is that if they decide they have too many cases, they might not hear them. So stay tuned. There's an opportunity to comment during this period of developing the regulations. I, for example, had asked even during those hearings years ago, if they could have a mediation process as part of this. It's not part of it currently, but they said we could make that recommendation during the comment period and they would take it into consideration. So that is the small claims court. 3 types of claims can be heard: copyright infringement, a declaration of non-infringement. And this might be something that you might do preemptively to prevent a copyright infringement claim, and challenges to DMCA takedown notices, which is what Katie described earlier. Defenses such as fair use can also be heard. We don't have a lot of discussion about fair use, but there are certain areas where you can claim fair use: parody, public information, etc., that might be fair use in certain situations. So that can be a defense.
I'll be surprised. I'm surprised actually that they ended up allowing fair use to be heard, because it is a very factual, subjective analysis. So it'll be interesting to see if anyone opts in if they're a defendant in that small claims, because it's very fact intensive. We'll see.
Well, that's right. And so the 3 judges could get wound up with a lot of discussion of precedent and comparing issues in previous cases and analysis and so forth. They might not be able to hear very many cases. I hope that's not the case.
It's a concern of ours as well that it's so limited in that way, because the whole idea is to make it more accessible. While you can bring an attorney, you don't have to. And it's supposed to be able to be done, I think, remotely, which of course now we're much more used to than we were even when this was being drafted, I'm sure, than before. But, you know, they're trying to eliminate as much paper as possible, as much inconvenience in terms of travel and attorney's fees. But I think it remains to be seen how it's set up, whether that will actually become the case.
Well, it's sort of interesting on another level. Many of the federal courts have mediation built into their case referral, case opening procedures. We worked with the U.S. District Court in San Francisco to present a mediation training, and they talked about how much they encourage all of their claimants to use mediation to try to resolve situations that might be more easily resolved between the parties rather than bringing them through the whole very expensive and cumbersome federal court adjudication process.
You know, Amy, our Director of Legal Services, Amy Lehman, is actually a Southern District of New York mediator as well. So she has her cases.
That's right. And in fact, the person that ran the mediation program in San Francisco for the U.S. District Court here was first trained through our mediation services. And so we were very proud of that one of our own mediators became the administrator of that program for a number of years. So it's odd that they're not already building that into the small claims process for copyright cases.
We still have the regs to go. Maybe we can.
Let's go on. I have no doubt that it would have been difficult, however, to get the parties that you referred to earlier into mediation, because obviously there was a high dollar amount involved. Nevertheless, sometimes at some stages, people see an opportunity to resolve a case that's in court at whatever level, and they will try to do that in order to save themselves the ongoing expense of additional attorney time, court time, travel time. So it's a very interesting thing when you look at these high dollar cases and try to think about, well, how could this have been in mediation? You can mediate claims about copyright, trademark, and so on, if people are willing to come to the table and sit down and talk and try to work something out. So let's talk more about mediation. We have a table to look at actually comparing mediation, arbitration, and litigation. We mentioned arbitration because our program, Arts Arbitration and Mediation Services, does provide arbitration, and it generally occurs when 2 parties to a written contract have an arbitration clause in that contract. And so what they're agreeing to is to bring the case to an arbitrator, a third party neutral, rather than going to court. It's also possible to say, as we often do in our MOUs with organizations, we may have had one in our MOU with Katie because we had a joint project at Columbia Law School a couple of years ago. And we always have some simple language saying that if there is any dispute, we will agree, we're agreeing to take it to a neutral mediation service to resolve. And it's not a fail-safe because people don't have to do it, but it does recognize that sometimes conflicts occur in business relationships. And it's a very common sense way to organize the resolution of a dispute rather than getting angry and going to court. So we always put that in our contracts and MOUs and collaboration agreements as a prophylactic measure. So let's look at mediation, which is less formal than arbitration. Mediation is administered through 3 of our offices in California. In Los Angeles, we have a staff person who coordinates the program, also in Sacramento and in the Bay Area. So we've covered the state pretty well in terms of mediation services. If you have a dispute, you would call and talk to one of the program managers and discuss your situation. If you want us to approach the other party, we can do that. We write a letter and say that John has asked to use our mediation services in order to resolve this dispute about the name of the band, for example. That comes up a lot. Or the return of the instrument, or the money that is owed that was invested in the project, and we take it from there. We follow up with phone calls and try to get both parties to agree to use our mediation service. The process is confidential compared to litigation, which is usually open to the public. And because artists are involved in small-ish communities where they live and work, it's often preferable to have a sit-down session with a mediator than to have your dispute aired in court. What you're saying in arbitration is that that third party will make a decision, but the mediator does not make a decision for you. You are empowered to explore the situation, talk about your emotions, your feelings, and then shape a decision that works for you, that the parties themselves craft. That's a big advantage over both arbitration and litigation. Sometimes witnesses and documents are provided in mediation, but not as proof. It's not evidence. On the other hand, in arbitration, there is evidence which each side is using to try to support their position. The arbitrator then makes a decision that takes the place of a court judgment. And of course, in court, you would need to provide witnesses and documents to prove your position to judge and or jury, as Katie pointed out. In terms of timeliness, we've arranged mediations in as few as a few days, as soon as a few days, if there's an urgent situation. Arbitration usually takes more time because we have to select an arbitrator with the consent of the parties. We provide a list of potential arbitrators, strike off ones that they don't want to hear the case, and then that takes some time to clear everybody and get the procedure set up. Litigation, as you know, can take years. It can take a decade to get a case heard and then through the appeals process. And frequently the result is unsatisfying. You don't know what's going to happen in litigation. You have no control over it. It's kind of a crapshoot. You don't know how the judge is thinking about precedents or inverse ratios. And you'll wander into a legal forest that you had no idea how that would apply to your situation. Arbitration costs less than litigation. And I think mediation is probably the most cost-effective alternative because we often waive fees for people based on their circumstances or their income, and we charge fees on a sliding scale. The last thing on this list is interpersonal relations, and I can't emphasize that enough in terms of how artists work. When you are making music with people, sometimes they become like your family. They often, the people that come to us with problems are having problems because of a personal issue that resulted, had nothing to do with the music, but the couple, for example, is breaking up and one of them says, okay, well, I'm out of here. And then you're left with, okay, well, who owns the music? Who owns the name of the band? Who owns the instruments, the royalties? Is there a question of money and that can be negotiated for credit? Is everybody getting the credit they feel they deserve? These things can be hashed out in mediation in a lot more empathetic way than certainly in court or even in arbitration, because people will have a chance to express themselves and to say what they're feeling. Courts are not generally interested in how people are feeling. Would you agree, Katie?
I would agree. I would agree. And, mediation does allow for creative solutions, right? That courts don't. In courts, you win, you lose, and money that's what you get, money. The judge is not going to say apologize, or give them credit or.
Yeah, and it turns as it's worked out, both of our systems use co-mediators. Sometimes we are able to get a lawyer who's an expert in a particular area, like a music lawyer, along with an artist, perhaps a musician or a visual artist, to help resolve the issue, help the parties listen to each other. And that's really important. It's an important function of mediation, is help giving people an opportunity to hear each other and to work out a creative solution, as Katie mentioned.
I think it's also important to note that the results of mediation are just as enforceable as litigation. So some people have the idea that when you come to an agreement with somebody in a mediation, that there's no teeth, and that it would have been better if I had done litigation because now I have a court order for something. But a lot of times in mediation, at the end, you'll sign a contract agreeing to what you have come to as far as the way to resolve the problem you had. And that's an enforceable piece of paper that you can.
Well, that's true.
That is teeth.
Let me just add one nuance, though. If you have a mediated agreement, it's like a contract.
Mm-hmm.
And you would need to, if you wanted to enforce some aspect of that, you might need to go to court to do that if the other party was not willing to voluntarily fulfill what they agreed to. Whereas if you get a court judgment, you can just go to a collection agency or the sheriff or whatever to enforce the court judgment.
And you can get a signed judgment so that if they don't comply, you can go and file the judgment.
They're usually self-enforcing because people shape their own agreement, and they might come up with terms for repayment or a way to share assets that may never have come out of a court decision, and they're happy with that. They feel like it's fair, and they've aired whatever their emotional issues were, and they can move on.
I will say, just another plug for mediation. It is a voluntary process, so we do have to ask both parties to come to the table. And you might have something that's been so entrenched and such a problem for such a long time, you think there's just no way it's going to work. And I have had Amy come back from like the start of a mediation say, I just don't see it. I don't see that they're going to get a resolution. And by midday, they've got a resolution. So it really is about having someone else help you communicate and hear what the other party has to say, and gives you an opportunity to press that pressure release valve and get to a solution. And so we have pretty high success rate in terms of once someone actually comes to the table for mediation, in the 95 to.
Wow, that's fantastic. And we like to say that mediation is win-win.
Yeah.
Litigation, which can be lose-lose, because even the winner has spent so much to get that result.
Well, and talk about enforcing.
You typically end up friends with people that you're suing.
No. And the creative community is very close, and you're going to be around those people for the rest of your careers. I mean, they're going to be around, and your reputation is important in the industry. So, I think it's a good alternative, and you don't lose anything. If you go to mediation and it doesn't work out, you could move on to litigation. But I think it's certainly, even if you're reluctant and think there's no way this person is you've been trying and they're just not going to get there, I would encourage thinking about mediation, because you have someone there who's trained, who can help you hear the other person and the other person hear you.
And they help you brainstorm options that you may not have thought of. So it can be a very creative process. And you can end up, if not friends, at least you can walk away from a situation without blame and acrimony, which is a goal. That's a value of a really important value. So we have a couple things to wrap up here. I want to describe the different services that we offer. We've discussed mediation and arbitration. Conciliation is a process where our staff will take on the role of the shuttle diplomat, for example, going between people and back and forth and helping them negotiate a solution without actually having people sit down in one space at the same time with a mediator. And sometimes this is effective for people who just refuse or are not able to be in the same space. Now, we used to do this with people that were located in different places. We've had a conciliation with people that were abroad or in the Caribbean, in Europe, and somebody was in America and we couldn't get them together for mediation. Now we can, because we're doing mediation on Zoom. And so things have changed a bit. We also offer facilitation, and this is a very flexible process depending on what people might want to do. For example, with a board of directors might be having some issues with staff, and instead of calling it a mediation, you say, well, let's have a facilitation and put all the issues out there. That can often work too with neighbor disputes and other kinds of situations that involve groups of people. We also provide negotiations counseling, where we're just working with one person to help them see how they can provide some options to resolve a situation. And then finally, we do trainings of mediators. We have a slide that goes through some of the kinds of disputes. We've talked about many of these. Credit for work that was performed. Of course, intellectual property disputes, trademark, copyright ownership, trade secrets, payment or credit for work provided. Sometimes these things can be traded off. If somebody's not able to pay you, you might want to make sure you get full credit. Damaged artwork or return of artwork. Sometimes we've had mediations involving music recordings. In fact, there was a case that was resolved recently when the producer had a contract with the artist to keep the recordings, and they didn't like that. When she moved, they broke up, and they broke up their business relationship. But through mediation, they were able to resolve it and work something out. So even though they had a contract that said something very concrete, they were able to negotiate the terms of that ownership issue for the music recordings to everybody's satisfaction. Partnerships and collaborations often are fraught with misunderstandings because people don't work out all the details in advance. And so mediation can be a very good process for resolving those kinds of issues, as well as contracts, fee collections. We have landlord, tenant, and real estate issues. We've also had some involvement with family law, co-parenting, and separation issues. As we talked earlier, sometimes these issues are interwoven with intellectual property that might be an asset of the family unit, and it becomes something that can be negotiated along with child custody and other kinds of issues involving family mediation. Of course, there are always neighbor disputes. We've had disputes around noise issues involving musicians. Can you imagine that? And other kinds of things recently, even involving COVID and behavior in common spaces and with neighbors. So it's a very fluid and fertile area for dispute resolution, and we hope you'll keep it in mind as you go through with your professional life, and it might be something you want to recommend to a friend, even if you never need it personally. For more information about our services, you can visit this page on our website. These are some classics in dispute resolution: Getting to Yes out of the Harvard Negotiation Project, and Effective Negotiating by Charles Carras. There are many more books about mediation, and encourage you to find out more about the field if you're interested. Okay, thanks.
All right, the first one is, in a patent, you can have multiple claims to cover a lot of things. Can you trademark multiple things like logos, and multiple songs within a single trademark application?
Yes, you can. If you have an application for your band logo and you're going to put it on all of your albums and you're going to put it on all your shirts and you're going to put it on your posters, you can do that all in one application. You just need to make sure that when you are registering all these different classes that you are actually using your trademark in commerce, because you're not supposed to be reserving your brand name for things you're not actually selling or providing a service of.
Great, thank you. All right, how about protection or treatment of covers or parody songs?
Okay, well, a cover of a song, you can record a song and you are licensing the musical composition, and you're allowed to do that under Section 115 of the Copyright Act, which allows anyone after the first use to record a song. I won't go into piano rolls, but there's a whole history back to 1919, I think it is, of why that's the case. Someone bought up all the pianos that could play all the music, and they said, well, everyone has to be allowed to be able to play these songs. And so this rule came about. But Section 115 allows a certain royalty to be paid. Some of you, I'm sure, know of Harry Fox, and that's where that comes from. So you are able to copyright your song, the recording, while licensing the underlying work. So parody, as Alma was alluding to before, gets into an analysis of fair use, right? And I wouldn't say if you're parodying it, that's a good question, Alma. Do you think you can parody, so you're claiming fair use, but then copyright it? I think that's a bit pretty bold. What do you think?
The question is, can you then copyright your parody?
Yeah.
And so nobody else can then use it?
Yeah. I think that gets into sort of a question that I like to pose to, more in the visual arts, when they're the appropriation artists, I'm like, well, would you want someone to use your work? And many appropriation artists are like, sure, go ahead. They're fine with that because it's part of the creative process, right? But wow, I think, that's an interesting question.
What happened to the 10-second sample rule? Are you really allowed to use a certain amount of bars before needing to call it a sample? And how does it work with sampling and copyright?
This is a misconception. Anything can be, well, I guess it's a good question, right? Because you look at the cases and there's 5 notes and there's 8 notes, but the 10-second rule, if you think about that, that's a lot of a song. And it depends. Usually what you're taking of that 10 seconds is the hook of a song, what I call the sort of name that tune of a song. So, looking at these cases, maybe there's some wiggle room, but there's never been any such thing. The question is a risk analysis. Is someone going to look at you using that 10 seconds and sue you in federal court, right? That's the question. But I wouldn't say, there's never been that rule. whether you make the argument and you go to federal court and you win or don't win on the 7 or 8 note copying, that's a different question. But
so this is copyright mythology, would you say?
Yeah, it is. Yes, absolutely.
Good to know.
It is lore.
For a smaller plaintiff against a larger, deep-pocketed defendant, why wouldn't the defendant opt out always of the small claims action to force the plaintiff into a costly, regular federal court case?
This is a good scenario as this small claims court tribunal unfolds. Yes, why wouldn't they? And just say, okay, I'm not going to do this and catch me if you can. So the opt-out provision is very strange. I don't know of any small claims court in the country that allow the defendant, I'm talking about superior courts now, state courts that have small claims that allow the defendant to opt out. I'm not sure why that's there. Do you understand, Katie? Do you remember any discussion about this?
It's a concern about your right to trial, and you can't force someone to forego their right to trial. So to get around that rule, they created the opt-out provision so that you have to voluntarily stay within essentially an arbitration, right? So it's outside the federal courts.
Is registration with BMI, Sound Exchange, and the MLC sufficient for establishing legal ownership?
Well, it's certainly proof, but if you have to file a lawsuit for infringement, you still need to be registered. Is that the question? You're trying to avoid being registered. So it's so inexpensive to register that if you're, releasing your work and you're registered with BMI and everybody, why would you not register your copyright?
So without it being registered, if there is any infringement, you don't enjoy the benefit of what registration provides.
Exactly. Including being able to sue. You would have to register before you could sue, and you wouldn't get, there's the statutory damages, the attorney's fees, the presumption of ownership.
Can you still copyright songs in a collection and have many, many songs in NSR?
Well, there actually was just, and I've just seen it in the notice and I haven't read through it, but I believe the Copyright Office just came out with something that extends the ability to file up to, I think, 20. I think that the answer is yes.
If I created musical works as well as recordings, should I register both PA and SR? And what is required by PA and SR as deposits?
I think you can, even if it's the musical composition, I think you can put the recording there, but I think you may want to, if you're going to the trouble of doing both, then do the sheet music for one and the recording for the other, I would say.
As far as copywriting music, how do I tell if we're registering as composer, publisher, or sound recording? And once we obtain the copyright, the songs must still be registered with MLC, YouTube, and all other platforms to actually receive streaming income. Is this correct?
Well, they're two different things, certainly, but you're going to have, unless you're your own, if you're self-publishing, and you are also doing the recording and you don't have a recording company or you don't have a music publisher, usually they'll take care of the collection of the royalties. If not, then you would need to make sure that you are a member of BMI or ASCAP, CSAC, register with Sound Exchange. So it just depends on if you're doing it all yourself, yes. If not, no.
Is it the same cost to file a copyright for an entire album of songs as opposed to a single song? And is there a separate form?
Well, I think if it's a single song, it's a little cheaper. Depending, as I said, I think, didn't we go through that, Keegan, a single author, a single work? There's been some questions over the years about, because it is pretty typical to register the whole album, it has been in the past for recording companies, but then there's been a question about damages because you can get damages for a single work. And so the question is, does that one registration mean one work, or does it mean the 10 songs that are on, or now the 20 songs that can be on a registration? So, given the cost, I guess you can make the argument either way. I don't know if anyone is aware of any decided law in that area. To be safer, do it separately, but it's pretty common practice to do it as albums, I think.
How can I properly use samples without infringement? And am I able to copyright my song that includes the sample?
So a couple of things. Yes, you can protect yourself by getting a license. And it's not unusual, even after you've created the work, to seek a license for the sampling part of the song. And the copyright that you'll hold will be for the creative elements. What you're creating is what we were talking about, the derivative work. So you would license that original work that you're sampling, and then around that, whatever you've created that's original would be your copyright. Even by copywriting it, you couldn't have rights over the sample.
When filing for a trademark, can you apply for a foreign worldwide trademark at the same time?
So there are no worldwide trademarks. You have to get a trademark in each country that you would like to sell your goods in or provide your services in. So there's countries that have treaties with each other that it makes it a little bit easier to file that trademark, but you can't get one that encompasses the entire world.
Thank you so much for joining us, everybody. Thank you, Keegan. Thank you, Alma. Thank you, Katie Wagner from Volunteer Lawyer for the Arts. We want to thank all of our sponsors, including Tape Op Magazine and NEVA, the National Independent Venue Association.
Thank you so much. It was a very rich program and love the questions. Everybody was really engaged, and we can't see you all, but we hear you. Thanks for joining.
Thank you very much.